Okay, before we get started with cross, as we were talking about the late file exhibit that Mr. Rooks is going to provide us with, the company, we'd like to have him available just to be able to explain that. So if we maybe want to call him back, if that's okay. Okay. All right. Cross of Dr. Hubbard, Mr. Guile.
Mr. Chairman, in the exercise of prudence and in order to expedite Dr. Hubbard's return to New York City, I decline cross-examination.
Thank you, Mr. Guile. ORS.
Good morning, Dr. Hubbard.
Morning.
My name is Steve Ham. I'm with the Office of Regulatory Staff. Welcome to South Carolina.
Thank you.
Mr. Chairman, I'm going to be prudent with my time, too. I have listened carefully, and we'll see if I've managed to practice what you told us to do.
Thank you very much.
In your line of work, economics, and I'm certainly familiar with you and have respect for your work, are you familiar with the concept of good faith and fair dealing in transactions in compliance with law?
That's really a legal question, and I can only answer from an economic perspective.
That's exactly what I'm asking you. From an economic standpoint, are you aware of the concept, good faith and fair dealings, from an economic standpoint?
Yes.
And what is your understanding of good faith and fair dealing as it deals with economics?
From an economic concept, good faith and fair dealing would be to follow established rules of the game, that is to honor those rules of the game and deal fairly within those rules.
Okay. Before we get more narrowly focused, I want to go to a broad issue, and that is, does the market reward inefficient companies?
No, it does not.
Okay, and how is that lack of reward manifested? In the stock price?
If your question about market is equity markets, yes, if I'm inefficient, my returns on invested capital will be too low, and as a result, my stock price, all else equal, will be lower than my peers.
And who's responsible for a company being inefficient?
Well, you know, success has 1,000 fathers and failure very few. But I would say, as an economist, that the failure would be market factors and management.
Okay. Now, have you, in the course of the economic work that you're offering today to this commission, have you done a study of the efficiencies of SCENG as a company as it relates to its management?
If I'm understanding your question, no. I'm not even sure how one would do such a study, but I haven't been asked to do that, no.
Now, let's start off with what I believe to be the fundamental basis of your testimony, and that is the BLRA wants this commission made a finding of prudence for them to proceed. I understand your position to be that prudence continues on and on. Is that correct?
No, that wouldn't be correct. This commission obviously can look to facts and circumstances to decide prudence, but yes, more or less, what has been approved, as long as it's conditioned on costs and schedule, remains prudent.
Okay. Now, you have made in your pre-filed testimony, you've talked about sort of political intervention. That's not the term you used. And you also talked about regulatory actions. Up to this point, has from your economic standpoint, is there anything that this commission has done that has been adverse economically to SCENG with regard to units 2 and 3?
I would say the commission is exercising what it's supposed to do, which is hold a hearing like this and it'll reach its decision. The issue that I described had to do more with the ORS proposals and the stock market's reaction to those proposals. That's not an action of this commission.
Right. And remind the commission how the stock market reacted when the company announced it was abandoning ORS, hadn't done anything. The commission hadn't done anything. But how did the stock market react? Remind the commission.
I'm glad you asked. It's actually a very important point. The market reaction upon the announcement of abandonment was basically nothing. The adverse reaction, that's because market participants assumed the BLRA was in place. The negative market reaction comes as a result of the ORS announcement, not the actual announcement of abandonment.
In preparing for your testimony, who did you talk to with regard, I'm not asking for the details, if you were talking with the council, that's fine, but who did you talk to that informed your understanding of the Baseload Review Act?
My understanding is based on reading the act as a layperson and also discussions with counsel, but I'm not here to offer the commission any advice on how to interpret the BLRA.
Okay. Well, but you expressed concern both in your pre-filed testimony and indeed during the summary that you gave the commission today about essentially what you might consider improper regulatory response to the abandonment of the summer units. That was one of the points you made in your summary, correct?
Not quite. I think what I said in each case was to the extent that markets perceive that as opportunistic. And that will depend, obviously, on decisions reached here and the market reaction to those decisions.
Okay. I want to go to, just so that we're all on the same. Now I understand why Mr. Scott Elliott was struggling around, because it's maybe more.
It's pretty high tech.
Yeah. Mr. Chairman, I did this in the hope that you'd be impressed that I wasn't going to try to delay things by using something on a computer. So this is my effort to
And it's appreciated.
Yes, sir. And Dr. Hubbard, with my glasses, quite honestly, that screen is not entirely clear. I know what it says. Is it clear to your view?
It's clear, although it's cut off, but what is on the screen is clear, yes.
Okay. What I really want to do is, this is language adopted this is the language that stated the intent of the Baseload Review Act by the General Assembly. And please notice that the prudency only continues if the company continues to act in a prudent manner. Don't you agree that that's what that is essentially telling us?
Well, I can't offer the commission any legal interpretation. The way I read that is really the balance point that I made before. But yes, there are bounds of prudence set at the beginning, and the company has to live within, I believe it was costs and schedule boundaries.
And in fact, that very concept is embodied in state law, which leads us to the proceeding today, correct?
I'm not sure what you mean by embodied in state law, but yes, this commission would be the body that would make this decision.
Well, let me go to state law, because I want to make sure you and I are together.
Make sure you wait till you talk, till you get in front of that microphone too, Mr. Ham, because we lose you on live stream.
Yes, sir, and you'd think I would remember that because I've heard you say it many times. Okay, Dr. Hubbard, what I want to do here is ask you to look at Section 5833-210. Uh, 225, I don't know how I got that number on there. Somebody who did that, I didn't even do this one trying to get it straight. But anyway, but the prudency when constructed by investor-owned utilities while at the same time protecting customers and investor-owned electric utilities from responsible. What I'm wanting to be clear on, have you, I see Mr. Willoughby standing up there.
Mr. Chairman, I rise to object because this section that Mr. Ham is referring Dr. Hubbard to, and Dr. Hubbard has said he's not a lawyer and is not going to give a legal interpretation, but this actually deals with project development orders, which is inapplicable to the case that we're here today about.
Well, Mr. Chairman, while I don't agree with that, I don't need to spend any more time on this based on his answer, but I don't agree with his assertion of what that covers, but be that as it may, mindful of your order, I'll proceed.
Okay, proceed.
All right. In preparing your testimony, again, I want for the commission to understand what you did to understand the management decisions, both early and late, that led us to this unfortunate situation where units 2 and 3 of the summer unit have been abandoned. What did you do in preparing your testimony?
Well, I attached to my testimony, I guess, the report of Mr. Jones. I read a number of things in the record. I'm not here to advise the commission on management actions. That's a finding of fact the commission itself will have to do.
So your economic recommendations have nothing to do with management. You're leaving that totally in the hands of the commission, and you are not attempting to inject an economic or any other opinion on that matter. Is that correct?
Not quite. The commission will have to obviously evaluate the evidence and decide management's responsibility or not. What I can say as an economist is the likely market reaction and effects to an opportunistic such decision. That's the only advice I can give. The commission will obviously find the facts.
Right, and you understand that South Carolina law allows, if the commission finds the fact, to make a ruling on whether or not certain costs were in fact prudent, even though there was an initial finding of prudence back in 2010. Do you know that as a matter of your preparation for this case? I know you are not a lawyer.
Mr. Chairman, that question, I object, that question does call for a legal conclusion. He's asking him to interpret the law and say what the commission can or can't do.
Hey, if you can answer it as an economist, it's okay. If not, we need to.
No, I agree. I'm asking him as an economist. Here this gentleman, Dr. Hubbard. I mean, I want and intend to be very respectful. You're offering an opinion on economics, and I'm trying to understand what the broad coverage of that term means. And I think I understood you to say, well, I didn't do a management efficiency review. The market sort of does that, I think was your answer. Am I correct so far?
Well, about half. I said markets are important, but no, I wasn't asked to do a management efficiency review, nor do I know how one would do such a thing, but no, I didn't.
Okay. So as a practical matter, you're not a lawyer, and then you may say that was some relief. A
room full of lawyers, I'll be somewhat careful. My wife divides the world into economists and real people, so I guess lawyers are still in the real people category.
Well, then you live in a different world than I'm in, apparently. But be that as it may, on a more serious note, I'm trying to, what is your understanding as an economist? You've read the BLRA, you're not a lawyer. What did you believe the BLRA provided to SC&G and Santee Cooper?
Again,
mainly SC&G.
From an economic perspective, the BLRA is an example of what I referred to in my oral remarks as a pure prudency ex ante regime, meaning that information is gathered at a time a prudency decision is made, and as long as that is carried out based on the facts at the time of approval, the costs would be recovered. That's my economic understanding. I understand in this case that parties aren't disagreeing on the endpoints, but are disagreeing in the middle at what point costs became imprudent. And I would just note that even if one accepted the March 12th, 2015 date, 55% of the costs, even not doing correct math, just ignoring present value, 55% of the costs would have already been prudent. So I think it's less extreme than the question you're asking, where the commission is now.
You made reference in your pre-filed testimony, and you said it again in your summary, about this balancing act between stockholders, ratepayers, and so forth. You remember that?
Right. That's why we have a commission like this. Otherwise, we wouldn't need one.
Well, please tell the commission from an economic standpoint what the economic benefits that ratepayers derive from the BLRA given the fact that we're here dealing with two abandoned nuclear units? What's the economic benefit to ratepayers?
Well, the way I think of it is the following. You think of economic benefit as before the fact and after the fact. So before the fact, the existence of the BLRA, which I would commend the state for having, made it possible for the company to raise funds at a lower cost than it would have otherwise. That's not just pat on the back of SCE&G, that's ratepayers. It's a competitive market, and you're passing that through into rates in the decisions you make. That's the decision you make. Now, to the point about failure having no fathers or being an orphan, when you get to the point of abandonment, I understand nobody is saying that it was imprudent to abandon this project. The question is who's going to bear the costs? And that gets back to the balance point. There are polls, the strictest, pure religious BLRA interpretation would be to say, well, that's just all customers. Another poll would say, no, it's all investors. In between, I gather there's a dispute really only after March 12th of 2015, after which 55% of the costs as a lower bound were already incurred. So from an economic perspective, that's really the only advice I can bring to bear.
Forgive me, but you didn't answer my question. What was the economic benefit to ratepayers to paying $2.1 billion in financing costs, and the project has been abandoned and it's never going to produce any electricity? What is the economic benefit to ratepayers?
I think it did answer it, sir. You got a lower cost of financing for a project that you thought, when it was approved, would happen and be useful. I hope I don't die this year, but the insurance premium I paid was probably still a good thing for me to do.
Well, I hope you don't die as well, just as a matter of human to human. But the fact remains is as I understand your position, your attitude is, well, they're not getting any electricity. They put out $2.1 billion. You're not happy with the General Assembly reducing the rates to the 126, whatever the number is. I read into, although you don't use a number, I read into that you're endorsing one of SCE&G's proposals in this proceeding. Is that correct?
It's not really for me to endorse. I can only note for the Commission's benefit that the merger proposal doesn't look too different in its allocation from the allocation of costs if you use the March 2015 demarcation. So I don't think my understanding from the record of this hearing, I don't think people are seriously debating an all or nothing, but are really somewhere in the middle, and I don't think those proposals are too far apart.
Okay. And is that an acknowledgement that you believe that, in fact, there can be a disallowance of certain costs, notwithstanding the fact that there was prudency found ex ante, which means prior to construction is how you use it, correct?
I can't say that from an economic perspective. I already told the Commission, if you do the event study, shareholders have already borne a large loss. So there is a loss being taken. The question is just whether going forward, what will be the effect of what might be seen as an abrogation of the BLRA? It's clearly not going to be positive. But if the Commission is in the middle looking at these alternative proposals, my only point is that the proposals that I think you're looking at aren't so far apart if you mean the March 12th demarcation and the proposal from the Dominion.
Didn't ratepayers lose $2.1 billion?
But investors have already lost more than that. When you have losses, somebody will bear those losses. That's an unpleasant fact, and it's hard for these folks because they have to make the decision. The pure BLRA and the opponent's view would have you on polls. I think the Commission is probably somewhere in the middle.
When you talk about polls, are you talking about polls of commissions around the United States?
Oh, no, sir. I mean polar opposites. So a strict interpretation of a pure prudency regime would say that if this commission had made a prudency determination and the company had lived within it, customers should bear 100%. Another interpretation is, wow, this thing was just flawed from the get-go, and investors should pay 100%. My guess is the commission's not at either of those polls, and whatever decision it will make, the stock market is somewhere in the middle as well.
I've just looked in my notes and found the phrase that you used in your testimony, and that was regulatory expropriation. Familiar with that term? Please tell the Commission of any examples that you have seen where this Commission is engaged in that kind of conduct.
Well, I'm not arguing this commission's engaged in that kind of contact. The sense in which I used it was if there are rule changes after the fact, markets will view that as opportunistic. Example of that was the stock market event study. So the announcement of abandonment, a big deal. Market doesn't move. The market only moves when it's effectively told the BLRA wasn't quite what market participants believed it was. That is a view in the marketplace that the decision is somewhat opportunistic.
Do you endorse the general view that the market, reflecting and looking at stock prices, that the stock prices reflect all that is reasonably known by investors in making decisions either to invest or not invest?
It would depend on the stock, but for this company, yes, that would be a characteristic of what economists would call an efficient market, that publicly available information should be reflected in the stock price.
So somebody who is conscientious in investing would have had the opportunity to look at the BLRA and recognize that there was language in there that suggested that imprudent costs might not ultimately be recovered, correct?
You're asking me for a legal conclusion.
I'm asking you if you've read the language, not an opinion.
I haven't. That's not how I read it. There are guardrails as to what ex-ante prudency means in terms of cost guidelines, in terms of schedule completion. That's my layman's interpretation. But if the law contemplated ex post reversals that are purely arbitrary, it wouldn't have been a law at all.
Again, I'm recognizing you've been offered as an economist. I respect that. I recognize you're not a lawyer, but you are sitting in the middle of an economic and legal circumstance. And so I'm trying to understand what it is you understood. I want to read a section of the code to you, and you as a distinguished economist, prudency applies in 5835 275A so long as the plant is constructed or is being constructed within the frames of 1, the approved construction schedule, and 2, the approved capital cost estimates. I just read you the statute.
I also think that's exactly what I told you 5 minutes ago.
But that language makes clear, have you made a determination from an economic standpoint whether or not the plant was being constructed within the approved construction schedule and the approved capital estimates?
Chairman, let me rise to object. I know Mr. Ham is trying to clothe his questions in, have you done this from an economic standpoint of view, but these questions really are trying to get at the heart of some legal interpretations that are going to have to be made to the statute. And I would object that it's really calling for a legal conclusion and not his economic analysis.
Okay, we're going to overrule. I think he can answer these from an economic perspective. So,
Sorry, could you repeat the question then?
Of course. South Carolina law says that prudency continues as long as...
Make sure you're in front of that microphone, Mr.
Sorry,
Ham.
Mr. Chairman. I thought my voice was loud enough it wouldn't make much of a difference. Can you hear me now, Mr. Chairman? Prudency can continue to be applied as long as the construction is following the approved construction schedule and 2, the approved capital cost estimates. And my question to you was factual, not legal. Have you made a determination or did you make inquiry about the approved construction schedule or the approved capital estimates?
No, I wasn't asked to do that. I can only observe that if you just look at the numbers in the proceeding as of March 12, 2015, without even doing a present value adjustment, 55% of the costs were already deemed prudent. In true present value terms, the number is probably closer to 2/3.
But you're telling the commission as you're offering your economic testimony that is not something you made inquiry in and did not form the basis of your economic testimony.
No, sir, that's a finding of fact. That's really for the commission to do, not for me.
Well, don't you examine the facts and the operating circumstances when you testify on economic impact on companies? It doesn't come out of the thin air, does it?
There's a difference between expert opinion and finding a fact. I can try to help the commission as best I can. The commission is going to decide whether the company was prudent or imprudent within the law. That's not for me to say.
I know, but you've just conceded that as part of you did not examine, when you're offering this economic testimony of yours, you did not examine whether they were within the approved construction schedule or their capital costs were in approved estimates. That's what I was asking you, and you just told me no. Isn't that correct?
It's correct. That would not be something an economist would help the commission on. That's for fact witnesses, and there has been testimony on that.
But you just told me a little while ago that if management is inefficient, ultimately the stock market has the ability to address equities by driving down their price, correct?
All else equal, sure.
Okay, so whether or not a company is within general confines is relevant to considerations of efficiency if a company is or is not. I'm not going to make an assertion one way or not, but you don't deem that to be relevant to an economic study, whether they're efficient and within the guidelines?
Now you're asking two different questions. I don't understand. Economists have a specific way of thinking about the word efficiency. You're using a more vague sense. I don't even know how you would study that. The sense in which it would be relevant for the analysis is really whether a departure from that is deemed by this commission to be imprudent. That's a finding of fact. All I can say as an economist is if the commission made that decision outside of market interpretation, there's a market response. That's all I can say.
It's a more market response, but you did not examine it with regard to SCNG.
I don't know what you mean by it. I've already said that efficiency, as you've defined it, I'm not even sure how you would do. In terms of whether the company's in or out of the bounds, that's a finding of fact. That's really not for me to do.
But you didn't attempt to obtain information to support your economic analysis. You didn't have an interest in exactly what was going on in the ground that got us to this situation today?
That would be very important for the commission for finding a fact. It isn't important for the analysis that I'm bringing to the commission.
So I understand from your testimony now you're not suggesting that this commission is engaged in any regulatory expropriation, correct?
I have not said that, no.
All right. But now let's talk about political expropriation. Tell the commission, be very specific in what you're saying. I understand you to be critical of subsequent efforts by the General Assembly to have an impact on the rates charged by SC&G. Is that what you're referring to?
Well, in general, the political element I'm talking about are political or elected officials changing rules of the game. Sometimes that happens in regulation. It can happen in ex post tax changes, a number of things in a variety of jurisdictions. That's the general family. For the General Assembly acts, those did seem, from an economic perspective, as retrading the BLRA. From an economic perspective, a better venue for that discussion was here. This very proceeding. You all are the ones who are going to decide the rates.
You just used the word, at least I thought I heard you say retrading.
Yes.
Well, I don't know what that term means.
In other words, not honoring a law that was in place. So
specifically, tell the commission what the General Assembly is not honoring.
Ex post changes in a law are inconsistent with the law's positive benefits. So I was asked earlier by counsel, why would you care before the fact? They have a BLRA in place. As I said in my written testimony, credit rating agencies praise the state of South Carolina a great deal for something like the BLRA because it did give certainty and it did give lower costs of capital. Any sense in which elected officials didn't really mean that is a kind of retrading, and there are market consequences for it. I have argued from an economic perspective the right way to continue to consider disagreements is before you all in a rate-making proceeding, and that's what you're doing.
So is it your testimony that what exactly did the General Assembly change that causes you to tell this commission that they engaged in political expropriation?
My concern is retroactive changes to a law when, in fact, this commission has both the right and responsibility to examine the prudence and set rates. The commission would have been the better venue for that kind of discussion. The fear one would have is that that kind of behavior on the part of officials means that next time a favorable law is enacted, investors or others may not take it quite as seriously. It's like the argument, what if we just have a one-time wealth tax? Well, one-time taxes tend not to be one time. So markets watch elected officials' decisions.
Well, to the extent you're talking about retroactive, the company always had a requirement under law. And again, I'm trying to be respectful of your position as an economist, but I still need to understand, more importantly, I want the commission to understand how you arrived at some of your conclusions. But the General Assembly didn't change the obligation that SC&G had to be prudent in every step of the way, did it?
It's asking for a legal conclusion, but my layman's understanding was that it was simply a revised rate schedule, temporary revised rate schedule.
So right now we're talking about the passage of legislation where the General Assembly directed this commission to issue an order changing the rates currently charged by SC&G. That's specifically what you're talking about.
That's my understanding of it, yes.
But the General Assembly left the final decision to this commission regardless, did it not?
This commission, my understanding as a non-lawyer, always would have the final decision.
So we don't know whether that was a problem or not at the moment anyway, because this commission hasn't issued an order, has it?
I think you're moving the ball. So the problem that I indicated earlier was the legislative action and uncertainty. This commission hasn't made a ruling, so obviously there's nothing that can be inferred yet.
Okay. Do you understand what the Office of Regulatory Staff is?
In a layman's perspective, yes, it's separate from the commission staff as a more technical staff. That's my understanding.
Okay. And its obligation is to do what? Do you know?
I don't know. I could offer a speculation, but
I'm
don't
not
know.
asking you to speculate. Well, the commission isn't responsible for the failure of these units, correct?
That's certainly true.
Okay, and ORS is not responsible for the failure of these units, or do you have a different view?
Now you're asking about a finding of fact question.
No, I'm asking about your opinion.
I'm not the finder of fact. I'm not here to give my opinion on who's at fault. The commission will decide how to appropriate and settle blame among parties. So I don't know. That's up to the commission.
All of your testimony is devoid of opinion. Is that what you're telling the commission?
No, not at all. But you asked me for a very specific thing. Am I going to say that the ORS is or isn't responsible? That sounds like a finding of fact, and that's not my judgment. That's the commission's.
So you haven't heard enough information to create your own personal opinion at this point. Is that a fair statement?
I'm not here to offer personal opinions. I'm here to offer expert opinions. So my views, one way or the other, on how to read evidence is not particularly material. What's important is how the commission reads it. There's been a lot of testimony and differences of opinion on both sides, and the commission will have to weigh that and decide.
What, if anything, do you know about the obligation of the company to report data involving the ongoing construction of the units 2 and 3? Do you have any understanding of just that requirement?
Again, it sounds like a legal question. My layman's understanding goes back to what you'd asked me about before earlier about schedule and cost issues. So if there were information about being materially outside one of those guardrails, layman's understanding, not a legal understanding, is that that should be reported.
So your testimony at base is, regardless of how we got here, the commission needs to do what?
Well, I'm not sure of your questions. Let me break it into two parts. The regardless of how we got here is an important predicate, because whatever the commission decides, who is at fault and for how much, there's still a problem here. Some costs have to get allocated, and you have to have a competitive environment that allows a utility to succeed. So in some sense, whoever did what, while it's important for the commission to figure out, doesn't really help on the second part. So that I think is really a decision. And the parties, as I said, their proposals in the record that don't look to me as so far apart.
All right, I want to make sure we're clear on what you're talking about. You're talking about specifically identify on this record what is not so far apart. What are you referring to?
Oh, in other words, if you look at the bid ask, if you will, on when something is, when prudency ends, my understanding is that the lower bound of that range is the March 12, 2015. By March 12, 2015, not even adjusting for present value, something like 55% of the costs were already in, so by definition, prudent. That number's really higher if you adjusted it in present value. What the commission will have to decide is it that number or is it some other number? That's what I meant in the record. If you look at the split that's envisioned in the Dominion proposal, investors are bearing at least as much as the loss in that, and the stock price already reflects that. So that's the sense in which I don't think there's too much disagreement.
In the Dominion proposal, the one that comes to my mind is where they're offering 9.9% return on equity, new nuclear development, what, $2.7 billion in rate base. Is that the one you're referring to?
I'm referring to, I think it's called Customer Benefits Plan or Merger Proposal. I understand the commission is looking at two different proposals, one of which front loads a refund and one which spreads it out. I could be either one fits that bill. The specific comment I was offering is on the one that had a large refund up front.
And do you have an economic opinion on the benefit of if there's a payment up front, doesn't that in fact involve borrowing dollars to do that?
You may or may not. Okay. The issue for the commission is really, are customers better off one way or the other, and that's a question about present value.
So your economic testimony in this proceeding is not attempting to suggest one path or another as far as the commission is concerned?
No, I wasn't asked to do that.
Please tell the commission how you prepared for this testimony. I mean, I appreciate, again, that you're not a lawyer. I haven't tried to make you one, but be that as it may. How do you go about preparing your testimony so it specifically applies to SCNG and the economic circumstances that is now in front of this commission? How did you prepare your testimony?
Well, in preparing the testimony and preparing to be with the commission today, I did my own affirmative analysis. I reviewed the reports that had been submitted by others and looked at the company financial documents that I cite in my report. My task as an economist is to try to help the commission think about trade-offs to balance. How to establish those trade-offs is inherently a political or regulatory function. It's for the commission to decide.
Who did you talk to? I want to know specifically. I'm not asking what you discussed. I'm not attempting to intrude into any privileges, but I want you to tell the commission who you discussed and talked with in preparing your testimony. Let's start with SCNG. Who did you talk with?
I didn't interview company witnesses. It would not have been necessary for the testimony I offered the commission.
I didn't ask you if you interviewed anybody. I asked who you talked to.
I meant that to be the same thing. So if you'd rather call it talk to,
you didn't talk to anyone?
I did not.
So how did you get your opinions? You're not a lawyer, but you've got at least layman's opinions on what you think the BLRA stands for. How did you arrive at those? That was not the result of conversations with anybody in the company that employed you?
No, it was not. I'm not sure why that would have been, but no, it wasn't.
So your preparation does not involve company-specific or management-specific decisions that had economic outcomes. That's just not part of your analysis.
Well, you've asked a number of things in there. The economic outcomes are definitely my analysis. The analysis of whether management decisions are prudent or not is for the commission to make, not for me.
Well, if a company's strike that. So I take it from that you're not aware of disputes about certain data that was not disclosed to the commission during the course of the construction of the VC units 2 and 3. You just, because you didn't talk with them, I guess you wouldn't know about that, correct?
I do know that there's a dispute. My point is simply I'm not the one in a position to evaluate who's right and who's wrong. That's for the commission.
Now I'm going to assume the answer is no, but I want to ask it for the record. Are you aware of an internal company analysis, estimate upon completion that the company did that was never submitted to this commission? Are you familiar with that dispute?
I'm familiar that there are disputes over whether internal information was or wasn't shared in the appropriate way. Whether it was or wasn't is not for me to decide. It's for the commission.
But you're aware of those?
That those disputes are there, yes.
And are you aware that those disputes could possibly have an impact on whatever I don't know any more than you do, what the commission might decide, though? That's part of the facts that they're going to need to find.
Right. Those are very important facts for a fact finder. I'm just not the fact finder.
Do you consider $500 million to be a substantial amount of money?
Where I said $500,000 is a substantial amount of money, so yes.
Okay. There was some testimony offered to the commission earlier in this proceeding where a witness said the company they bet the company and they lost. Do you agree with that analysis?
I didn't hear what that witness said or context, but I don't view this as betting the company and losing. This was a decision the company and the commission came to. You make ex-ante decisions with the best information you have. Some of those decisions work well and some of them don't. I can buy a stock and it goes up, and I can buy a stock it goes down.
Or it goes bankrupt.
That's also possible when you make an investment. You have to judge an investment decision based on what you knew at the time you made the decision.
I don't have any further questions, Mr. Chairman.
Thank you. Any more cross?
Mr. Chairman, I have a very limited cross. I can probably get us out of here by noon.
We're going to stay a little longer than that anyway. You just get you out of here by noon and we'll be good. Thank you, Mr. Cleveland.
Morning, Dr. Hubbard. My name is Will Cleveland. I'm an attorney with the Southern Environmental Law Center representing the Coastal Conservation League and the Southern Alliance for Clean Energy. I'm going to ask you just a few questions about the summary that you read. Is it safe to say that investors are tracking very carefully what happens in this commission proceeding?
Yes, I think that's fair, both in terms of the spread between the two stock prices at issue and just the value of SCE and G, yes, or SCANA, yes.
And is it safe to say that investors were aware of the BLRA over the last 10 years and what it meant for the regulatory investment environment in South Carolina?
Yes, that was the point that I made.
Yeah. This is your summary, and you state that retroactively exposing investors to risks they did not agree to take on would amount to changing the rules of the game after it had started. Is that correct?
Yes, that's exactly what I said.
This is Section 280K of the Baseload Review Act, which has not changed in the 2018 legislation, as I understand it. And it says, starting in the right in the middle, it says recovery of capital costs and the utility's cost of capital associated with them may be disallowed only to the extent that the failure by the utility to anticipate or avoid the allegedly imprudent costs or to minimize the magnitude of the costs was imprudent, considering the information available at the time. Do you see that?
Yes, I think that's what I said earlier.
So you would agree that the BLRA has always had a provision where, in the event of abandonment, imprudent costs would not be recovered?
From a layman's perspective, yes, if they violated guardrails.
Excuse me, Dr. Hubbard. That again is I object, is literally calling for a legal conclusion. He says, do you agree with me that that provision has always been in the law?
Sustain.
Mr. Chairman, I'll ask another way. This is back to your summary, and you're talking about how investors will view the General Assembly changing the rules of the game. Is it your understanding that the investors, as far as I understood the rules originally, knew that disallowance was possible in the event the costs were imprudent?
By those two guardrails, yes, they knew that.
Okay, great. This is my last question. Let's put aside the 2018 legislation. Let's assume the BLRA is what it was a year ago. And let's assume that this commission finds that the costs after 2015 were imprudent. You've talked about balancing. Do those costs go into this commission's balance?
That's what the commission will have to decide. I can say that to find that, the commission would need to believe that something happened outside the guardrails of agreed upon prudency from decisions they've already made. What I can say is, and have said, is that that allocation doesn't look too far off of what Dominion's already proposing to the commission.
But does it go into the balance?
Balance is something the commission will do. That would be an example of balance. Whether there are costs in the long run from that and the cost of capital remain to be seen.
No further questions, Mr. Chairman.
Thank you. Any other cross? Mr. Knapp.
Mr. Chairman, appreciate it. Mr. Hubbard, good morning by a few minutes. I'm Frank Knapp. I'm the pro se intervener in this case. And again, welcome to South Carolina. In Mr. Willoughby's introduction of you, he went through, not that I understood why, your compensation. Did I understand that your rate is about $1,500 an hour and you've invested about 60 hours in the preparation for this testimony?
Yes, sir. Both are correct.
Okay, good. Thank you. First of all, congratulations. That's very notable. I know that there's other people around, including myself, who got out their calculator real quick and did the math on that. So, but that's it's good for you. But since we didn't understand why Mr. Willoughby was making that information available to everybody, I just want to make sure that it wasn't because, and you don't agree that the amount of money paid for somebody's expert testimony makes it any more valid or important than any other witness that's prepared for this case.
I completely agree with that.
Thank you very much. I appreciate that. I thought you would. Now, in your direct testimony, is it your position that this commission should not order that the experimental rates should be made permanent?
That's a finding of fact. All I can say to the commission is that that sort of decision does risk this retroactive policy change and higher cost of capital in the future, tilting the balance away from the equilibrium we were in. That's all I can say. The commission will have to decide that.
It would, from your point of view, it'd be really a financial problem for SC&G if they approved the experimental rates.
I think it goes in that direction, yes. The commission has to decide the balance.
So if your opinion then on the experimental rates is correct, and SC&G agrees with your opinion, SC&G would be committing financial suicide if it agreed voluntarily to accept the experimental rates as permanent. Would that be correct?
No. Financial suicide sounds like that's a guarantee for bankruptcy. I haven't seen that information presented to the commission. What I'm saying is it is pushing in the direction of making the financial integrity worse off, potentially raising the cost of capital and future rates, urging the commission to know what it already knows, that actions that benefit ratepayers and customers in the short term may come back to bite them in the long term.
Sure, I understand this, sir. Thank you very much. But so you're not saying that SC&G should not accept the experimental rates because it would be too financially difficult for them.
That's a business decision SCE&G will make, or more likely, if the commission approves a merger, that the combined entity would make.
Okay, which I'm glad you brought that up. And so if Dominion also accepts your opinion regarding the impact of the experimental rates, should they be less likely to want to continue with the merger if they became permanent? I'm sorry.
That's a question for Dominion. I think their CEO was here. I assume you or others asked him that question, and his answer would be their answer.
Okay, I guess I'm asking for your expert opinion on that. So that's not a deal breaker either then?
That's for Dominion to say. I'm simply saying it becomes more negative. Dominion management will have to say, well, given all of that, is this deal still worth doing? That's a business judgment they all have to come to.
And if the commission were to decide that the experimental rates didn't go deep enough or far enough in a rate rollback, say they wanted to go to 18% rate rollback or 19%, what would be your opinion on the consequences of that?
Well, I can only point out the trade-offs. That's going to push more likely to much higher cost of capital and, frankly, to less likelihood that the merger is consummated, leaving the original company, SCE&G, in a much worse financial position. The commission will have to evaluate, its caring about that versus the customers today.
But it's not a guaranteed deal breaker for Dominion to want to continue the merger.
That's a business judgment decision for Dominion. I would think they'd want to do the numbers awfully hard under the proposal you made, but that's their decision to make.
Mr. Hubbard, thank you very much.
Thank you.
No more questions.
Thank you. Any other cross? Commissioners.
Mr. Chairman,
Commissioner Whitfield.
got one question for you, Dr. Hubbard, and it's purely economic. You stated in your earlier in your testimony that SC&G equity investors have lost around $2.1 billion. Then you go on to say later between $2.1 billion and $2.5 billion, and then later you go, the total loss in market capitalization was over $3 billion. When Mr. Ham was questioning you, you said that the market didn't really move on the announcement of the ceasing of construction on the units. In your expert opinion, how much of this equity investors' loss is related to the news of the cease of construction versus other factors such as regulatory opportunism that you had a lengthy discussion with? In other words, can you put a percentage or dollar amount on those ranges you gave for the loss of these equity investors?
Yes, sir. Great question. And sorry if I wasn't clear. So $3 billion is the total drop in market cap over that period that I indicated in the event study to the end of that year. The 2.1 to 2.5 is attributable to the regulatory change. In other words, if you look at event dates related to regulatory policy and public policy and do a cumulative abnormal return, that is a return netting out market factors, depending, I did it two ways. One way is 2.1 billion, one is 2.5. So the answer to your question is how much is attributable to the policy uncertainty? That's the 2.1 to 2.5. So conservatively, if you want to take the lower number, 2.1, under the other, 2.5.
And the other is from the announcement of the cease of construction. I mean, how about the other?
No, sir. The difference there is just not filtering out other things. So if you just ask the question from point A to point B, the market cap declined by $3 billion. But that could have been because of the overall stock market or utilities generally. So filtering all that out, it's 2.1 to 2.5. I'm sorry if that wasn't clear.
All right, thank you, Dr. Hubbard. That's all I have, Mr. Chairman.
Thank you. Commissioner Elam.
Thank you, Mr. Chairman. Good afternoon now. At page 10 of your direct testimony, you talk about implementation of the acts causing economic harm to the general public interest of the state of South Carolina, and you also talk about spillover effects down at line 13 on page 10. Could you explain what you mean by spillover effects?
Certainly, I was referring, and I think I do later in that testimony, to empirical studies that look at the effect of regulatory uncertainty in one area on others. So, for example, other utilities may have their cost of capital going up, even though they have nothing to do with this proceeding. And some studies have also studied business climate generally when regulatory uncertainty or legislative uncertainty in a state goes up. So that's what I meant by spillover. The two sets of studies I reported in there was one spillover to other utilities and the other to general business.
I thought I was reading a reduction in similar investments, and I didn't know whether you meant nobody's going to try to build a nuclear power plant here.
That would certainly be, I meant more broadly in utilities, but yes, nuclear power for sure.
And the chance of that anyway is pretty low at this point, wouldn't you think?
Well, I would think generally in the United States right now, that's a tough call.
Okay. At page 25 of your testimony, you talk about the BLRA was passed to avoid the disincentive to invest. Why was there a disincentive to invest?
I'm sorry, sir, where are you on the
Page 25.
Page.
It's the question in the middle of the page.
Oh, yes, in other words, this is just changing from the BLRA. In other words, the BLRA was a pure prudency regime as long as you're within the guardrails. The legislative action would seem to change that, back toward the dial of a used and useful regime.
I'm trying to understand whether you meant that perhaps no one would remotely invest in a nuclear power plant construction unless there were a real mandated lowering of risk. Is that about right?
More or less, sir. It's a question of, what's the required cost of capital for a nuclear power investment where we know there's huge uncertainty. And one of the things that rating agencies said about the BLRA when it was passed is that it was very favorable to guarantee that kind of lower risk structure going forward. So more or less, yes, to your question.
Okay. Again, back you spoke about at page 10 and also on page 32 that implementing the Act 258, the rate reduction would chill investment in South Carolina. Was that your testimony?
I don't know that I said chill, but yes, it definitely goes negative. It's basically raising the cost of capital because there's now a risk premium, and so that would reduce investment all else equal, yes.
Okay. Do you mean that by utilities or anybody?
I was referring to utilities. There's a general literature out there on spillovers to other industries, but the comment here is about utilities.
Do reasonable, stable utility rates encourage economic development?
I believe they do, sir, yes.
Is that what was created during the construction of this plant?
I'm not sure your question, sir. It's certainly the case that a regime that seeks to produce reasonable, stable rates is good for economic development. Ex post, if something happens and there are losses, you all have to decide how to allocate those losses.
You were, in your summary, you were discussing the timeline, I guess, of the construction, and you were talking about what was known at the time, and you said that large gas price decreases have been in effect for about a decade. Is that my understanding?
I think what I was saying is over the decade, gas prices went down, but obviously sitting in 2008, you wouldn't know what gas prices are in 2018.
When did gas prices due to shale start to go down?
I don't recall the exact date, Commissioner, but technological improvements were happening almost throughout that period.
Was it prior to 2012, prior to 2013?
If you're asking were the hydraulic fracturing technologies available before then, yes. The ultimate impact on gas prices, which is a statement about both supply and demand, would not have been known in 2008. But yes, the existence of the technology was certainly known.
You don't know, you can't tell me when gas prices started to be significantly lower than they were prior fracturing.
I don't recall, sir, sorry.
Okay. You discussed with Commissioner Whitfield amounts about SC&G investors and what they had lost. And I think you had said, he talked about between 2.1 and 2.5 billion in value prior to the merger. Is that what I understood?
Yes, sir, that's correct.
Is it possible that value was due to an inflated stock price, due to the lack of information about the problems of construction?
I don't think so, sir, because much of the information that's been talked about here, including the Bechtel report, was public before the large decline in the stock price.
I'm asking you about the rise of the stock price. Could that be related to a lack of any reported problems at the site?
If I'm understanding your question, one would look for a curative from an economic perspective if you think you've had inflation. And to the extent that the curative is any of the things that have been talked about here, they were in the market before the price went down, meaning they couldn't have been a curative.
But certainly the stock price was rising over the period 2010 to 2017.
As were stocks generally.
Thank you, Mr. Chairman. I have nothing further.
Thank you. Commissioners, anything else? Mr. Willoughby, any redirect? What? Wait a minute. Hang on one second.
I have one question.
Commissioner Urban, sorry about that.
Yes, sir.
Of the two Bechtel plans, Plan A and Plan B, do you have an opinion as to which plan would best serve the customer or ratepayer in terms of when you consider present value?
I'm sorry, sir. When you said Bechtel, do you mean the Dominion plan?
I didn't. No, I'm sorry. I meant the Dominion plan.
Okay.
I've been listening to you for so long about it.
I'm sorry.
I misspoke. The Dominion Plan A and Plan B, I want you to tell me which would be more preferable if you're looking solely at present value.
I wasn't asked to do that calculation. It would be an easy one to do and come back to you on, but I would argue that if customer interest is your goal, then you should just pick the one that makes customers better off. It could be that Dominion has given you those numbers. I just haven't done the calculation.
Thank you. No further questions.
Thank you. Commissioners, anything else? Mr. Willoughby.
I have no redirect, Mr. Chairman, and we would ask that Dr. Hubbard be excused.
Thank you. Dr. Hubbard, thank you for being here, and we appreciate your travel, and your testimony, and you are excused.
Thank you, sir.
Thank you. Let me, we're gonna break in just a minute. I know we have, and I think parties have spoken about having Transco's witness, Mr. Alatorre, who's come in. Have y'all got a plan for that so we can?
Mr. Chairman, I'll give you the plan as best I understand it. We have two date certain witnesses, or two groups of witnesses set for date certain this afternoon. We have the Transco witness. We also have an additional SC&G panel. We believe the Transco witness will be up and down relatively quickly, and so we think it makes sense to start after lunch with the Transco witness. I would note, as I've tried to make clear to particularly the ORS this afternoon that the panel of SCE and G witnesses includes Dr. Ken Petrunik. Dr. Petrunik has to be off today. What we would suggest is that panel go up as constituted, those three individuals. Hopefully all cross of them would be complete today. But if there is a risk at some time later this afternoon that it wouldn't be complete, that the parties focus their cross-examination on Mr. Petrunik or Dr. Petrunik so that we could bring Mr. Young and Mr. Kokum back if that became necessary. That's where we are today.
Okay, that works fine. So we're going to go first with Mr. Is Mr. Alatorre already here? Why don't we go ahead in just the next few minutes, get him sworn in on the stand, and whatever we need to do preliminarily, and then that'll get us a few minutes ahead of time. Mr. Richards, we'll get him sworn in, and make sure your microphone is on. You punch the little button, the little red. Yeah, there you go. Speak into that thing.
Mr. Chairman, I'm Jeff Griffith here on behalf of Transco, and I have a few questions for Mr. Alatorre. Mr. Alatorre, would you please give the Commission your full name and business address?
Hector Alatorre, 2800 Post Oak Boulevard, Houston, Texas, 77056.
By whom are you employed and in what capacity?
I am employed by the Williams Company's sole owner of Transcontinental Gas Pipeline Company, LLC. And my capacity is Director of Customer Services for Transco.
Mr. Alatorre, did you prepare or have prepared under your supervision pre-filed direct testimony consisting of 12 pages filed September the 24th, 2018 with this Commission?
Yes, it was prepared under my direction.
Is there any change or correction that you would like to make to that testimony?
No.
If I asked you those questions today, would your answers to them be the same?
Yes, my answers would be the same.
Mr. Chairman, we submit Mr. Alatorre's direct testimony to be entered into the record as if given orally from the stand.
Mr. Alatorre's pre-filed direct testimony will be entered into the record as though given orally from the stand.
Mr. Alatorre, did you prepare or cause to be prepared under your supervision 2 exhibits to be annexed to the pre-filed direct testimony numbered HA1 and HA2, which were filed on September the 24th, 2018?
Yes, the 2 exhibits were prepared under my supervision.
Do you have any changes to those exhibits?
No.
Mr. Chairman, we would like Mr. Alatorre's exhibits to be entered into the record as the next composite exhibit.
Mr. Alatorre's 2 exhibits, HA1 and 2, will be entered as exhibit number 140.
Mr. Alatorre, did you prepare or have prepared under your direct supervision supplemental pre-filed direct testimony consisting of 2 pages filed November the 12th, 2018?
Yes.
Is there any change or correction that you would like to make to that testimony?
No.
If I asked you those questions today, would your answers to them be the same?
Yes, my answers would be the same.
Mr. Chairman, we would ask that Mr. Alatorre's supplemental direct testimony be entered into the record as if given orally from the stand.
Mr. Alatorre's supplemental direct testimony will be entered into the record as though given orally from the stand.
Mr. Alatorre, did you prepare or cause to be prepared a summary of your testimony?
Yes.
Mr. Alatorre, would you please read your summary into the record?
Yes. Again, my name is Hector Alatorre, and I'm employed by the Williams Company as the sole owner of Transcontinental Gas Pipeline, LLC, as Director of Customer Services for Transco. In my pre-filed testimony, I discussed Transco's concerns for the potential pressure which Dominion Energy might exert over its new subsidiary, South Carolina Electric and Gas Company. Transco provides firm and interruptible transportation, storage, and LNG peaking services for South Carolina LDCs, end users, and other shippers, including SC&G, SCANA, Energy Marketing, Inc., and other consumers located on SC&G's system. Transco anticipates that the Atlantic Coast Pipeline will extend from its current terminus in North Carolina into South Carolina. Dominion is a 45% owner of the ACP. If the ACP extends into South Carolina, Transco expects certain safeguards need to be in place to prevent self-dealing between Dominion and South Carolina Electric and Gas. In my pre-filed testimony, I suggested a number of safeguards that would prevent this sort of self-dealing, which would be a benefit to the ultimate South Carolina consumers of natural gas, whether commercial or residential. After filing my direct testimony, Transco entered into settlement discussions with Dominion and SC&G, which ultimately resulted in the settlement agreement, which was signed by the interested parties and filed with this commission on October 24, 2018. It is Transco's belief that the settlement agreement between the parties reflects a fair resolution of the concerns that Transco expressed in my original testimony and that the commission should approve the agreement. This concludes my summary.
Mr. Chairman, Mr. Alatorre is available for questions from the commission and cross-examination by the parties.
Okay, we're going to need to break right now, and we're going to need to break until 1:45. So we'll come back at 1:45 and have cross, and we'll break until then. Thank you.